Hey everybody, it's Jason Cruz once again with MMA Payout. We are doing another interview. This time we are talking to trademark attorney Erik Pelton from Falls Church, Virginia. Is that correct, Erik?
That's right, just outside of DC, about 5 miles.
Excellent. And we are going to talk a little bit about trademarks. As everybody knows, in the world of combat sports, whether it be MMA or professional wrestling or even boxing, there is a need to file trademarks. And so Erik will kind of guide us through what's going on, how to file a trademark, and what's kind of going on in the battles for the trademark. So tell us a little bit about yourself, Erik, how long you've been practicing, what type of stuff that you do.
Yeah, thanks for having me on. I've been doing pretty much exclusively trademarks for 20 years now. I started my own firm in December of 1999. That was after a brief stint at the U.S. Patent and Trademark Office as an examiner, reviewing applications, accepting, denying, all those kind of things, kind of learning the process of the application and registration process from the inside out. And then in those 20 years, I do about half applying and registering trademarks and about half dealing with disputes and litigation and agreements related to trademarks.
Okay. And then tell us a little bit about what the attorney examiner does. Now, when you file a trademark, it goes directly to one of an examiner. How many examiners are there? What are their functions?
Yeah, so I think there's about 350 examiners now. They're broken up into approximately 20 or so different offices and teams. Mm-hmm. When I was there, we were in teams sort of by subject matter, by classification. So all the clothing marks would go to, one team, all the cosmetic marks. So you would learn an industry a little bit more in depth. Now they've done away with that, and pretty much everybody gets all types of applications except for a few extreme circumstances.
Interesting.
And believe it or not, the first thing that happens when you file is it just sits there. I know you know this, but for the listeners, when you file a trademark application, the filing date is important because you get a filing date, you get a serial number, you're in the public records, and you start having some rights. But the Patent and Trademark Office doesn't even really pick up the file and begin to examine it for about 3.5 months on average.
So that's a very interesting thing, and also interesting for people that call me up and immediately want to file this mark because they want to get it, and they ask, well, am I going to get it next week or next month? Usually it's going to be more like 6 to 8 months, assuming no issues with the mark.
Yeah, I tell them actually about a year on average,
okay,
just to be safe. And just because when you factor in, some don't yet have use and you have to file an allegation of use later, or there could be an extension of time to oppose. There's so many different potential obstacles throughout the process. The fastest they go through is about 6 to 8 months, and then I find the average to be about a year.
And that's assuming, that there's no issues with it, as far as like either an examiner finds likelihood of confusion, or it conflicts, or it's merely descriptive, things of that nature. Because if that happens, then it kind of takes a little longer, correct?
It can, yes, because when an office action, so once the examiner gets assigned the file and they review, they're reviewing all of the qualifications, whether it's meeting all of the procedural standards and qualifications, as well as the substantive ones. And the main substantive ones are descriptiveness and likelihood of confusion. Those are the main, most common refusals for substantive reasons. And if they issue a refusal, whether it's for a procedural or a substantive matter, it's called an office action that they issue. And it might be something very simple that only takes 5 minutes to correct, or it might be something really complicated. But the applicant gets 6 months to respond to the office action, regardless of the nature of what's in it.
Excellent. So let's go right ahead. The UFC, Ultimate Fighting Championships, has an event this coming up Saturday, one of the first sports to get back into action.
Right.
Dana, actually, let's go first to one of the main event people that are fighting on Saturday is Tony Ferguson. And he actually, 2 years ago, filed for a mark entitled Champ Shit Only. And the mark application was actually previously filed as a 1A, which means he claims he was actually using it. And if it's a 1A, let us know. You actually have to provide a picture or some sort of specimen that you're actually using it, correct?
Right. So there's the two main applications are 1A and 1B. 1A being used in commerce already, and 1B meaning you have an intent to use it in the future. There's also a few other bases based on foreign filings, but those are, relatively less common.
Go ahead.
No, I was just going to say, when you file 1A, or when you go to convert an intent to use application to a use application, you have to submit proper evidence of use. That's one of the procedural requirements that every application has to meet somewhere along the way before it will be approved and registered. And the types of evidence can vary in terms of what's acceptable, and it depends on whether it's a physical product good or whether it's a service. Then the nature of the evidence can differ for those two things. Mm-hmm. And it's a very important part that cannot be overlooked.
Right. And so Ferguson, he wanted to sell T-shirts and hats and things of that nature with the emblazoned Champs Shit Only mark. And his specimen that he submitted was just a Twitter picture of himself with Champ Shit Only. And so that was not immediately, but it was denied by the USPTO because they indicated it didn't reflect what he had registered for, which was clothing, apparel, those types of things. So with that in mind, the denial based on a Twitter photo, what would you have said to him or his representatives as far as submitting that specimen? It seemed like it was out of what he's supposed to submit.
So social media posts can be good evidence, but it's relatively rare when they will work as really effective evidence. And that's pretty much going to be limited to when it's for services that relate to promotion and online services. Now, a social media post that's a picture of a phone or, a product, then really the evidence is the product itself that happens to be in a picture that's posted on social media. So then the screenshot of the social media could be acceptable evidence. But here, where it's just a tweet, with like a promotional, a picture of the fighter, maybe that would be evidence for the services of like promoting the celebrity or entertainment factor of the fighter. And lots of celebrities and athletes have those services for trademarks. Mm-hmm. But again, if his goal was to protect merchandise and clothing and apparel, there's no way that is going to be an acceptable specimen, because there's no clothing using the name in there, in the photo, in the tweet. There's nothing for sale in there, in the tweet. Usually to show an online screenshot for clothing or something using a mark, you need to show the ability to purchase it online, like a shopping cart, add to cart type of button, or buy now or something like that.
So would it be able, if he actually had a shirt that just said Champ Shit Only, and like emblazoned with some sort of logo with the name, and he tweeted that out, would that be somewhat acceptable?
This raises a lot of potential issues, which is first why anybody with a trademark should hire an expert like yourself or any of the many other trademark experts, right? Because on the one hand, like filling out the forms seems relatively easy because there's, just a bunch of questions and blank space, but there's a lot of nuance to getting all of these things right. Mm-hmm. And so if it was a picture of just him wearing a shirt that said Champ Shit Only on it, mm-hmm. that's probably not acceptable either, because it doesn't show it for sale. And if it's just across the front of a shirt, that's what's called an ornamental use usually. And an ornamental use might be protectable, but it's probably weaker because it's not really indicating the source of the apparel. So when you think of a clothing brand, you think of something like Fruit of the Loom or Hanes, right? Because you can find it on the tag or the hang tag when you go to buy it on the sleeve, or Nike or Adidas or Under Armour, right? Because the packaging and the tags all indicate where it comes from, what store you would go to buy more, who you would return it to if there was a defect. All of those things go to indicating the source of the goods, which is the real function of trademarks. And just displaying it on the front of a shirt isn't really the same thing. But trademark law has this sort of intermediate where if it is ornamental, you can have some protection on what's called the supplemental register.
Right.
And then you get into these brands like Life is Good and Salt Life that are like started out as expressions on the front of clothing, but also use it on the tags and websites and stores. And so they've become a true brand, even though it might, the primary use to the viewer is kind of ornamental.
So it wouldn't be one of those things where you could just iron on your letters and just have it, life is good or something like that. That's probably would not pan out.
Definitely would not recommend that, because that's not even a legitimate, there's no sale there. You also have to have actually made sales, have had commerce in order to claim that it's in commerce, and you have to have a date of use. And nobody's asking for an invoice or a receipt necessarily, or verifying the date of the first sale. But if you're ever challenged, you have to be able to establish those things.
Right.
Or you could lose your rights, or you may have, committed fraud in the filing, or, opened up a can of worms.
Yeah. So Ferguson's either he has another attorney, or they reconvened. He has converted it to a 1B. So we go into a little bit about what a 1B intent to use filing is, as opposed to 1A.
1B intent to use applications are really useful. I file a lot of them for clients, particularly if they're just launching a business or just launching a new product or service, and they've just come up with a name. They hopefully go through the process of clearing that name to make sure it's unique in their industry and likely to be available and free of relatively low risk in terms of an infringement or a dispute. And then they can file immediately based on that intent to use, even if the launch might be several weeks away, it might even be several months away. It could even be a couple of years away, where you could file based on the intent to use. Because if they don't file and start that public record with the trademark, they have exposure in the interim. And the example that I like to use on this is like a car manufacturer. You can imagine when Ford or Toyota comes out with a new model of cars, the Ford Taurus, that there were years of planning and design and naming that went into that before the first Taurus ever rolled off the factory or ever was bought in a dealership. And if Ford had never filed a trademark application for the name, they wouldn't have really had any rights to it until the first sale was made. Oh. And at any point during that time, if one of their competitors had, for whatever reason, come up with the same name or a similar name and started making sales before them, or filed at the trademark application before them, that other competitor could have had superior rights, because Ford wouldn't have had any rights until that sale. But Ford, by filing an intent to use application early on in that process to say, we're not going to be making sales for a while, but we filed a 1B application now we have rights as we go forward with the steps to plan and launch it until we get to the actual commercial use.
So basically Ferguson's attorneys or legal counsel has decided to convert it, and he wasn't out of luck. When the USPTO came back and said, sorry, we are not accepting your specimen, he just had to amend the application to a 1B, which allows him to file what's called a statement of use, basically, which is amending showing the specimen later on once they've started operating under it. Correct? Right.
So as happened with the Ferguson application, when you start out under 1A, you can go back to 1B. Whether you start as 1B or you turn into a 1B, you still need to submit the evidence of use, the specimen of use, as you say, or statement of use. And then the USPTO will review that. You can't you can't undo the statement of use usually. So at that point, he won't be able to go back again. In other words, once he commits to filing evidence now, he has less flexibility in terms of filing additional or substitute evidence. I will say though, like when they rejected his initial evidence, he could have submitted other evidence if there was other evidence that would have shown that it was being used at the time the application had been filed, that it was being used properly for the apparel and the other goods listed. Since he didn't, one would guess, based on what happened, that he didn't have that evidence, that's why the best decision was to amend to the 1B.
Okay, let me hold on for 1 second. So with Ferguson's application, he can still provide, whenever he decides to sell merchandise, apparel, he can provide that so long as it's within the parameters of the limits within the application, correct?
So when it's an intent to use 1B application, you have to pass all the other requirements in order to get the preliminary approval from the USPTO. Once you've done that, they will publish the application in the public record.
Yes.
That's when somebody could potentially file an objection or an opposition or an extension. After, assuming nobody files that, which is relatively rare that somebody would file, assuming nobody files that, then the USPTO will issue a notice of allowance that basically says everything in your application is all set except for the evidence of use. Whenever you submit the evidence of use, we'll review it, and then if it's approved, you'll get the registration. The initial notice of allowance term is for 6 months to file the evidence of use, but you can extend that for additional 6-month increments for up to a total of 3 years. So that's 3 years from the date of notice of allowance, which is several months or more after the initial filing date, which is why I say that, the forward process could be 2-3 years from when they file the application to when they're ready and need to file the evidence of use.
So let me ask you an interesting, quirky trademark question here. What if somebody else, maybe a fan of Ferguson, wants to sell these types of T-shirts with the same emblazoned champ shit only, and has a logo and does it, but files it now after Ferguson has done this, is now in what is the 1B intent to use. And they just kind of, and they say, oh no, we filed it, but we'll wait them out. And then he files an extension and an extension and an extension up to the requisite amount. Does that person have to wait?
Well, first, if that person, was inspired by Ferguson using the phrase and knew about his apparel or his, that might put the kibosh on the whole thing, right? Because they might have had sort of bad intent. But putting that aside, they would probably have to wait it out, because basically, if Ferguson gets the registration, his rights in some way go back to that initial filing date, which trumps the fans filing, and he would be able to stop them.
Even if they were ready beforehand. Even
if they were ready. Well, the other thing is that when the Patent and Trademark Office goes to review the second application, they're only searching their records of previous registrations and pending applications. And so they would, especially if they're identical, they would see Ferguson's pending application, and they would note that in the second application file, and they would actually not let the second file get approved or move forward in the process while the first application was ahead of it in line. And they would, if there were no other issues, they would suspend the second application pending either the registration or abandonment of Ferguson's application.
That's an interesting point. It's happened to me, and it's with trademarks. It seems like it's all about priority. You got to get there first before for anybody. But which leads us to another UFC trademark. Actually, the company UFC. One of the things that they intend to do with this global pandemic is to have fights on a fight island. And so they've filed for the trademark Fight Island in several respects,
Okay.
as well as UFC Fight Island. One of the things that I noted when they made this announcement a couple months, last month, was that there was only one mark application that had Fight Island to it, and it was a movie company, but they had abandoned that mark. So the first question I have for you is, if mark is abandoned, can another person or another entity go ahead and attempt to register that mark?
You know, every case, of course, can be unique and have nuance. So I will say, like, generally, generally, the abandoned record at the USPTO has zero value. So I told you the USPTO would search for its records for potential conflicts, but they don't care about the dead marks. The dead marks are or abandoned marks. They're listed in the USPTO record as dead as opposed to live. That's why I refer to them as dead marks. So the dead marks have no value in that role when the USPTO looks for conflicts within its own records. However, that's not necessarily the end of the story, because if they abandon the application, let's say by accident, or they got blocked from registering it, but they went ahead and used the name anyways, the previous applicant. If they are still using the name, and therefore if their use precedes this current idea of Fight Island and these current applications, that earlier company, that earlier business might still have a grounds to block those applications or object to them based on their earlier use. But they would have to go through a more complicated process of either opposing the applications or litigating an infringement situation.
Interesting. So one thing I note is that all of the UFC's, Zuffa's trademarks are filed under 1B, which we talked about, intent to use. They have already, just looking on their websites, are starting to sell T-shirts with Fight Island logos, those types of things. So can they? So the basic question is, can they use that even though they're under 1B right now?
Well, yeah, there's nothing that prevents you from using it while it's pending.
Okay.
You know, it is safer, ideally, to wait until it's further along in the process. Your risk goes down. Okay. Your risk of an issue with the name goes down after the USPTO says there's no conflicts. Then it goes down more after you get published and nobody objects to it. But the risk never goes away. And of course, every business has different risk tolerance. And UFC didn't really have any choice here, or Zuffa didn't really have any choice here, because the time between when they came up with the idea, filed the applications, and the event happening, right, was so compacted they couldn't wait 6 months to see what happened at the trademark office. They couldn't have had this idea last summer because nobody would have had this idea last summer. So it is what it is. And frankly, as a matter of reality, it's a lot easier for big companies to accept the risk because they can afford to fight, to dispute, to buy out somebody. They have all kinds of options if there should be a dispute. Whereas for a small business, it's much riskier. So if this were a small business client of mine, I would want to make sure that they knew about the risks that they were undertaking, because, it's a lot riskier investment for the small business.
So say if, we're operating on 1B, they're starting to sell T-shirts, they start to have an events in June or whatnot. And then let's say August, the examiner comes back and says, it's actually like there's a likelihood of confusion or something, in which it blocks the UFC from actually obtaining the mark. What does the UFC do at that point? What do their trademark attorneys do at that point if they now get this notice from the USPTO that, hey, you can't register Fight Island, but they've already invested all this money, done these events, that kind of thing? What happens then? Do they stop using it, or what do they do?
So it's not a requirement that you have a registration to use a mark. So just like they're using it now or very shortly without a registration, they're allowed to do that. There's no obligation that you file to protect it, even though it has tremendous benefits and is highly recommended that you go through the application and registration process. So if they got an office action refusal due to a potential conflict, they could just let it lapse and say, we'll just use it without a registration and take the risks. Now, that means it's harder for them to do a takedown online or to sue somebody for infringement. It just makes everything a little bit more cumbersome, a little bit harder, a little bit more expensive. Again, not as big of a deal for UFC as it is for a smaller business to deal with those expenses and challenges. But the other thing is, they would have the opportunity to respond to the office action. So they could argue that there's no conflicts. They could investigate the cited registration to find out, is this actually still being used? Or is it actually used in the manner that it's listed in the registration? And could they could potentially file to cancel the registration if it's not in use?
Oh.
Or they could potentially reach out to the registrant to seek an agreement, whether it involves money or other things, to seek their consent. So there's to me, this is what makes trademarks like fun every day, is that there's so many variables and variations.
Right.
Every case ends up unfolding as its own story, its own unique path, because there are so many different splits in the ways it can go. Another thing I noticed about the Fight Island marks is they filed a lot for Fight Island by itself, but they filed a bunch for UFC Fight Island.
Right.
That having UFC in the mark means it's less likely to be a conflict with something else because it has the UFC element in it. So that might also have been a part of their thinking in terms of why they spent the additional fees to file both Fight Island and UFC Fight Island.
I see. And so just going back to your one point about if they cannot register the mark, do they go ahead and, well, if there is a likelihood of confusion assertion by the USPTO examiner, could that other mark, if they ever were to find UFC Fight Island, could that mark go ahead and sue for trademark infringement?
Well, they could. They couldn't really do it just based on the USPTO's refusal, but the grounds of the refusal, the reasoning of it might hold up in court as well. They certainly could allege infringement. The standards for infringement, while they're very similar to the standards for renewal and likelihood of confusion, are not quite the same, because a court will take a broader view of what is actually happening in the marketplace. And so, a court may say, nobody's going to confuse this with UFC Fight Island because it's clearly its own thing and it's marketed as part of UFC and it clearly involves MMA. And so if this other Fight Island thing had nothing to do with MMA and nothing to do, I don't know, we could make up a hypothetical, but it's not guaranteed that a court would find it to be infringing just because the Patent and Trademark Office found it to be an obstacle.
Gotcha. Interesting. Very, very interesting stuff. Let's move on to the world of professional wrestling. And the reason why we go into this is because the World Wrestling Entertainment has a slew of marks. And one of the interesting things that's happened recently is that they've let go a lot of their talent, a lot of their independent contractors. And with that, a lot of the independent contractors were performing under a character name. And that character name were at one point trademarked by the World Wrestling Entertainment. But what's happening is some of the performers are arguing that they should be the rightful owners of the marks. So kind of give us a little bit of guidance as to who actually owns the marks when with an employer-employee relationship. Oh, well, excuse me, employer-independent contractor, employee-independent contractor relationship.
So the biggest thing there, I think, is going to be the contract, the agreement,
Okay.
And what's in writing. And these sports leagues, these wrestling entities are not, they're not new to this, right? Mm-hmm. And they have a lot of investment and a lot of lawyers. And so there's no doubt in my mind that they draft the contracts very favorably to them, and that it's very believable that the contracts say that WWE or other wrestling entities own all of the intellectual property of the characters, the names, the stories, even maybe the costumes and the look of the characters. Any of that is possible to be agreed to in writing. There could be some creative arguments when the talent gets so well known that they have like some right of publicity maybe that blends with this, that if they go out on their own, how could, they can't, I mean, I think the most well-known case of this that I'm aware of is when The Rock left.
Yes, I was about to
his own career, right?
I was about to say that.
People are going to call him The Rock even if he didn't advertise himself as The Rock, right? He could say, my name is Dwayne Johnson, all he wants. People are still going to call him The Rock. WWE can't sue, or I apologize if it wasn't WWE.
Yeah,
whatever wrestling league it was.
It's WWE.
They couldn't sue the media or the fans for calling him The Rock. They could sue potentially The Rock for promoting himself as The Rock. But they both have, I think, a financial interest to have resolved that.
Okay.
So I wouldn't be surprised if, and I have no knowledge of this whatsoever, but if he has to pay them some sort of royalties or percentage of what he makes, particularly where it's advertised involving The Rock, back to WWE because they helped create and launch that character.
Now, could he, assuming he's like a lesser known character, he doesn't have a right of publicity, as the big star that Dwayne Johnson is, could he say the artist formerly known as The Rock? Could he use that as a moniker, or is that still something that the WWE, if you are a WWE trademark attorney, is that something that you would look at?
There probably is something along those lines that he could do relatively safely, because you can't stop someone from like reciting the facts, right? Or reciting history. So it's like a fact that he was a WWE wrestler known as The Rock. That gets clunky to say, in a movie title, but that's still possible. Just come up with some phrase like that. I don't, that doesn't stop the WWE from challenging it either.
Right.
And again, that's where it all comes down to money, unfortunately.
Yeah. And so as far as a character's name, if you are if you're like a professional wrestler and you do well, and then you are signed by World Wrestling Entertainment, and the WWE wants to, and you represent the person, and they want you to hand over the rights to the character name. Is that something that is negotiated? I mean, in these types of transactions, there are character names and ownership of them, and I guess intellectual property is an asset. I mean, how does a business deal with that?
Yeah, well, businesses deal with intellectual property assets all the time.
Yeah.
Every employer generally has contract terms about the intellectual property that their employees create, generally being owned by the employer. And it can be important to have work for hire agreements. It can also be important to have non-compete agreements as part of employment provisions. So while they're fun and interesting in the wrestling context, these same kind of issues can come up in any employer, in any industry. The unique part about the wrestling is that you could take both sides, right? That like the character would be nothing without the person. Even if the script is written, the person has to embody it and play it out and live it out. On the other hand, the wrestling league promoter would say, if we didn't promote it, if we didn't advertise it, if we didn't give you an arena full of fans, nobody would know. You could have a wonderful character and nobody would know about it. So we're the ones who have the TV deal. We're the ones who have the sponsors. We're the one who fill the seats, and it's sort of a chicken and egg
Right.
situation.
Well,
But
yeah.
go ahead.
Oh, no, I was going to just say that, yeah, I mean, I think that one of the things is the wrestling league would definitely have the argument that they made the investment in promoting and promoting the brand and having the person on television or on air or do their character. The character could also say, the fact that you own the name doesn't mean that you own the person. So you can't, it's not like you're going to use that name, that character again. You're not going to put that person, put another person in that character, so to speak.
So two sports sort of parallels. In the last 10 years, you've seen a lot of professional athletes start their own brands. I mean, it started with Air Jordan, and then it has slowly evolved to, to every all-star level talent in the NBA and many in football and NFL and MLB have their own brand. So Mike Trout has his own brand. TB12 for Tom Brady has his own brand. Chris Paul has his own brand. Sneaker deals, athletic deals. So it's more now than just being sponsored by Adidas or Under Armour or Nike or some other company. They create their own brands. And there have been some disputes about that because sometimes the apparel manufacturers design the logos for them. And so those contracts are important as to who owns the actual logo and the brand. But I think the athletes have been smart in those cases in developing their brand that can then be larger than the team or the current endorsement deal. And they can take it with them as their career goes on or after their career. So LeBron James has done a great job with this as well. And Kobe Bryant had done a great job with that as well. The other sort of parallel I was going to say that's actually different is NASCAR. The numbers in NASCAR are like part of their characters almost. The drivers have the numbers, but it's actually the teams that own the numbers, I believe. And so when a driver switches from one team to another team, which happens sometimes when their contracts run out, they usually have to switch numbers because the numbers stay with the teams. I don't know what the genesis of all this. I don't know a lot about NASCAR history, but you will see NASCAR drivers from time to time change numbers, which is kind of interesting. You would think, why couldn't they just be the 77 next year
throughout,
for
but
the
like
other team?
the team owns the mark. I see. I mean, it's subtle, but interesting. And then I think the Kawhi Leonard trademark case, trademark copyright infringement case that was actually up here because it was Nike that was being sued, is a definite example as to the need to protect the brand because Kawhi kind of put his logo together, but then Nike made it better or something like that, and Kawhi ended up losing that case. So, but anyway, Erik, thank you so much for your time. Let me ask you a quick question as far as a trademark practitioner. It seems like so easy to fill out mark applications, but it's definitely much harder. And I think you tweeted out something a couple of days back about how mark application is like art, yeah. And explain that a little bit because I find that I agree with that so much.
Yeah, it really is like an art as much as it is a science. It is a science, right, in the fact that there are manuals, there are cases, there are thousands of things you could read about trademarks, and it would give you some idea of what to do. But as we discussed on just those limited examples, without even digging in too deep, there are so many different factors and different directions it can go and different decisions that have to be made along the way, that it really is an art to feel out what's going to be the best way to do this to represent the client's interest, to get it through as smoothly as possible. And it's also an art because, I believe there's a lot of talk about artificial intelligence and, computer and algorithms and software and how much they can replace work that professionals do. But I really believe that it's the experience of having seen and helped, sometimes with failures or hurdles along the way, so many applications that educates and informs each one that we're going to file the next time, and that we've learned from that. And I don't think you can teach that to a machine. All those decision points that were made and why they were made and what ended up happening and what lessons were learned from them.
Excellent. So tell us where people can find you, Erik.
Yeah. So they can find me at erikpelton.com. That's ERIKPELTON.com. There's a contact me button there. I'm on all social media. It's easy to find me. I also just recently wrote a book, my first
congratulations.
book. Thanks. It took a lot of work, and it came out in the spring of 2020, which was an odd time.
Oh my goodness.
But the feedback has been great. And it was really like taking everything that I had written and learned over those 20 years and all that I had learned about also building my own brand and my own business and putting it out there. And it's called Building a Bold Brand. Oh. And you can learn more at buildingaboldbrand.com.
And that's where you can get the book?
And that's where you can also get the link to Amazon to buy the book. Yeah.
Oh, excellent. Excellent. Well, Erik, thank you so much for your time. I greatly appreciate it. I have learned a lot from our short time here. And it was great to talk a little bit about trademarks and combat sports. So thank you very much.
Thanks, Jason. It was a pleasure.
Excellent. Thank you.